The United States Supreme Court is stepping into a fight over a six-pack of beer and a Cessna airplane. The justices have agreed to hear a case from Alaska pilot Ken Jouppi. In 2012, he was convicted of bootlegging after a passenger brought a six-pack of beer onto his plane bound for what's supposed to be a dry village in Alaska. Well, Alaska confiscated his $95,000 aircraft as punishment. Jouppi says that violates the excessive fines clause of the Eighth Amendment to the U.S. Constitution. Here's what he said after the Supreme Court agreed to hear his case. Quote, "I'm in my 80s now, and I've been fighting this for over a decade because I see it as my duty to ensure that the Bill of Rights actually means something in protecting against government overreach." Let's bring in constitutional attorney Mark Smith. Mark, I'm a pilot, so I have some sympathy for private pilots who lose their airplanes. But under what law is Alaska allowed to seize this guy's plane?
Well, the Alaska state law says that if you are trying to bring alcohol to a county or area that is dry, which means no alcohol law, then yeah, one of the penalties, in addition to going to prison for a few days, is that you could lose your plane. So the question, of course, before the U.S. Supreme Court, John, is whether or not that Alaska law, the practice of how that law works, when it bumps up against the United States Constitution's Eighth Amendment that says you cannot have excessive fines. The question is, how is all that going to play out? And that is what the Supreme Court is going to clear up next term. And I think there's an excellent chance that Mr. Jouppi is going to win this case, because certainly losing your plane, which could be your livelihood, is a really big deal. And over bringing beer to a dry county when it wasn't even yours, it was your passengers, I think that's a bit of a stretch, and I think the Supreme Court's going to see it that way as well.
Yeah, so just to be clear, this wasn't his beer. The beers weren't open. This was something that a passenger brought on board. The passenger was he was going to fly this passenger. It was very common in Alaska where there aren't many roads. He was going to fly this passenger to Beaver, Alaska, and Beaver is supposed to be a dry village, no alcohol allowed. And for that, he lost his airplane.
That's right. And again, what the issue presented here, John, is how do you define what is excessive, an excessive fine? And it really, the Alaska Supreme Court and the way it's been interpreted is that, look, we ask, why was the law enacted? The law here, making an area dry, no alcohol, was to address really serious social ills, alcoholism and all the health problems that are derived from that. And the question is that what a court is able to look to figure out if something's excessive? Or is it what Mr. Jouppi says, is you look at the specific facts of what the criminal defendant actually did. Here, he didn't fly the plane off. It never took off. He never served the alcohol. There was no victims. It's a malum prohibitum crime, meaning it's just a crime because it was said so by the legislature. And he says, if you just look at the facts of my case, which is the right way of doing it, it clearly violates the Eighth Amendment for me to lose my plane. So that's really the fight. What is considered by the courts to determine what excessive means and whether or not excessiveness has been met in a particular case?
Yeah, but it's pretty hard to define excessive for every single state and every single potential violation of law, isn't it?
Well, what the Supreme Court does is they make a note that says the Constitution was written in the 18th century. They then consult historical resources like dictionaries at the time, Blackstone commentaries, other legal commentators at the time, and said, when the founding fathers of the United States adopted the language of the Eighth Amendment, what exactly was the right, or what were they concerned with? And then you take those principles that were deemed to exist in the 18th century and you apply them to modern circumstances. That's the whole notion of originalism. And there's ample historical evidence that when you're trying to figure out whether or not it's an excessive fine, John, you look specifically at the conduct and the harm caused, if any, by the specific criminal defendant. You don't take into account kind of global societal ills and put that burden upon an individual defendant. It has to be very particularized, and I think that's what the Supreme Court's going to say. And when you look at the specific facts of Mr. Jouppi here, it just doesn't justify losing his plane over some cans of beer that were never opened and he didn't even own.
Yeah, the Wall Street Street Journal seems to agree to you. I just want to read this before we jump to another topic real quickly. But the Wall Street Journal writes, a case of beer for the Supreme Court. Great headline. In 2023, 45 states collected nearly $300 million, according to the Institute for Justice, which represents Mr. Jouppi. This aggressive law enforcement diminishes American civil liberties, and the excessive fines clause should be a shield against such overreach. Mr. Jouppi's plane sure looks like it qualifies. So, again, we'll keep an eye on this case and see where it goes. Real quickly, I want to play this from Justice Elena Kagan. She has been accused, or she's answering accusations, I should say, that the Supreme Court is just a rubber stamp for President Trump. Listen.
The first thing is this a really conservative court? The answer is yes. The second question is this a court that does whatever the current administration wants? The answer is no. I don't see this as a court that is just like, we're just going to rubber stamp what the current administration does. Quite the opposite. I actually think that there are significant times with respect to very significant issues where the court has checked the executive branch.
And I'm sure, Mark, the president would agree with her on that.
Yeah, it's interesting, John, how the left wing in America controlled the Supreme Court for decades and decades after Franklin Delano Roosevelt was the president, and there was no concern about rubber stamping the progressive agenda or FDR's policies or anything like that. Only since conservatives, originalists have sort of become the majority on the court do we start to hear these complaints. And clearly, Justice Kagan is correct, because there's many instances where the justices disagree with President Trump's views on birthright citizenship, on the Federal Reserve case involving Lisa Cook, obviously on the tariffs case. There was a Second Amendment case where the Supreme Court came out against what Donald Trump's position was. So, yeah, it is clearly not the case that this court is a rubber stamp court for President Trump. And there's many cases I disagree with on the Supreme Court. But again, that's how it works. Sometimes the judges don't agree with your arguments, and this Supreme Court doesn't always agree with President Trump.
You win some, you lose some. All right, Mark Smith, constitutional attorney. We appreciate it. Thanks.
Thanks, John.
Be sure to like and subscribe for all the Fox News latest on YouTube, and catch full shows streaming now on Fox One.